Thank you so much for calling this important hearing. I thank all of our panelists for attending, particularly Mr. Beatty and Mr. Griggs, who is from NASDAQ, which is located in the district I'm privileged to represent. I look forward to all of your testimony today. This hearing will examine 4 legislative proposals that are intended to make it easier for companies to raise capital. While I'm interested in hearing our witnesses' thoughts on these proposals, I do have some serious concerns with some of the bills as they are written. H.R. 4850, the Micro Offering Safe Harbor Act, creates 3 entirely new exemptions from the requirement to register securities. First, the securities will be exempt from the registration requirement if the buyer has a, quote, substantive pre-existing relationship, end quote, with an officer of the company before he buys the securities. Second, the securities will be exempt as long as the company, quote, reasonably believes, end quote, that there are no more than 35 buyers who have relied on these new exemptions in the previous year. And finally, the securities will be exempt if the company hasn't sold more than $500,000 of securities in the past year. Based on the title of the bill, I believe that it is intended to apply only to very small offerings of securities, or, quote, micro offerings, as they're so called. However, the way I read the bill, it actually applies to all offerings, no matter how large, as long as the buyer has a substantive pre-existing relationship with an officer of the company before he buys the security. I am concerned that this would blow a hole in the securities law because a substantive pre-existing relationship could even be developed during the company's sales pitch to the investor. It is important to note that we are already seeing a trend toward the use of unregistered private securities rather than publicly registered securities. In fact, the private securities market is now larger than the public securities market. In 2014, companies raised $2.1 trillion through the private securities market compared to only $1.3 trillion through the public securities market. I believe we need to take a step back and think about whether this trend is a good thing. Clearly, this means that more securities are being sold with fewer investor protections. Are investors in these securities being harmed or exposed to risks that they don't fully understand? Or are investors capable of bearing these risks, which they fully understood before they purchased the securities? These are important questions that I think we need to ask 4 years after the Jobs Act. Finally, another bill we will consider today, H.R. 4854, would significantly expand the number of investors who can invest in venture capital funds that are exempt from SEC oversight. Under current law, a fund can be exempt from SEC oversight if it has less than 100 investors and its securities are not offered publicly. A fund with fewer than 100 investors, which is not marketed publicly, poses fewer investor protection concerns than large funds that have lots of retail investors in them. This bill would raise that threshold from 100 investors to 500 investors, but only for venture capital funds. I would like to hear from our witnesses why this change to such a long-standing rule is necessary and what problem are we trying to solve. So I'd like to thank all of our witnesses for being here today, and I look forward to a robust discussion. Thank you so much, and I yield back the balance of my time.